will now be recorded.
I'd like to open up the Public Works and Protection meeting on Tuesday, August 8, 2023. Roll call.
Gary Paul.
Here.
Kelly Service.
Here.
John Burnett.
Here.
Joanne Euclid. Here. And Krieger's excused.
Okay. Pledge of allegiance, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Action on the minutes, July 11th.
Move to approve.
Got to back up one. My lovely lady to my left has got to help me out tonight. Action on the agenda.
Move to approve.
I thought I heard you already. First and a second, all in favor?
Aye.
Opposed? Motion carried. Okay, action of the minutes on July 11th, 2023. Any corrections or comments on that one?
Move to approve.
Move to approve.
Second.
First and a second, all in favor?
Aye.
Aye.
Motion carried. Item 6, comments from the public must limit to the items not on the agenda. Must state your name and address. Got a 5-minute to listen to you. Board rules to listen and not discuss the item. Personal issues cannot be discussed or names of people brought up. Board is not able to take action on this meeting. Anybody here that is not on the agenda? And it looks like the screen is clear. Okay, we'll move on. Action items. Action on Class B liquor license request for 608 Axe Throwing, doing business as 608 Axe Throwing. Joel, you are the man of the night.
All right, thank you, Mr. Chairperson of the night. 608 Axe Throwing LLC, again doing business as 608 Axe Throwing, is requesting approval of a Class B beer license, beer only, for 303 Bay Park Square, Suite 201C. If you recall, Blades and Boards was in this location previously with the same type of license. It's a new owner. All paperwork and corresponding fees have been filed accordingly. The entity is currently working under a provisional license, and staff recommends approval. Thank you.
Same license, different person to apply. Okay, any questions on this one?
Move to approve. Second.
First and a second, all in favor?
Aye.
Motion carried. Thank you. Action item B. Action in Class B / Class B liquor license for SBG Apple North 1 LLC, doing business as Applebee's Neighborhood Grill and Bar. Joel again.
Okay, Applebee's Neighborhood Bar or Grill and Bar has a new owner, which happens to be SBG Appleton North, the first LLC. They are requesting approval of a Class B beer, Class B liquor license for their location at 900 Hanson Road. All paperwork, corresponding fees have been filed accordingly. They would be working under a provisional license until this is approved. Staff has reviewed the application materials and recommends approval.
Okay. Any questions on this one?
Move to approve.
Second.
First and a second, all in favor, say aye.
Aye.
Opposed, motion carried.
Can you mention that these are all going to village board?
Oh, okay. Yes, all these will go to the village board for final approval. Item C, action on Class A, B / Class A liquor license requested for Squared Capital LLC, doing business as Ridgeview Liquor.
This is a request for a Class A beer and a Class A liquor license for a business called J Square Capital LLC. They'll be doing business as Ridgeview Liquor. That particular store had a change in ownership, and that new owner is requesting the license. This approval would be contingent upon surrender of the existing license by the current owner. All the paperwork and corresponding fee have been filed accordingly with the clerk. Representative, I believe, is in attendance tonight. If you have any questions, staff is recommending approval.
Change of ownership is the only thing, Joe? That's it?
That is correct.
Who's the person buying it? Don't screw up my good liquor store. Okay, any questions?
Will it still have the specialty bourbon in the back room?
You're well-known already. Okay, can I have a motion, please?
Move to approve.
Second.
First and a second, all in favor?
Aye.
Opposed? Motion carried. Again, this will go to the village board for additional approval.
Again, contingent that they
Contingent on,
surrendering the,
well, surrendering the license that is in action right now. Item D, action on Class B/Class A liquor license request for Lala Café and Catering, doing business as Lala Café and Catering. Joe again.
Okay, just to make a quick note, the agenda should read, as it states in the application materials, that this application is for a Class B beer, Class B liquor license. The agenda says Class A, however, the application materials in the agenda packet corresponds to the correct application. So again, a Class B beer, Class B liquor license for Lala's Café and Catering. They are looking to do business at 2052 Holmgren Way. If you're familiar with this area, it is the former T. Bacon's Barbecue restaurant. Previous to the request for Lala's Café and Catering, T. Bacon's did hold a Class B beer and a Class C wine license for the restaurant. The facility itself is relatively small in scale and in comparison to maybe other like facilities in the community. And so the village board, when it issued licenses to T. Bacon's, did so with the idea that it would be for Class B beer and Class C wine license only, not the full combination license. They will be getting a provisional license. In fact, they picked it up today, so they are able to operate under a Class B beer and a Class C wine license until the village board makes the final determination on the extent of the license itself. All the paperwork for this and corresponding fees have been filed accordingly, according to the clerk, and representatives for Lala's Café are in the audience as well if you have any questions.
So this is just for a Class B and a Class C wine license only at this point?
At this juncture, the applicant is requesting the full Class B combination license. However, it is noted that previous to Lala's Café's request, the former tenant or operator in that facility was only granted a Class B beer, Class C wine license.
And wine, okay.
Right. It is my understanding the village board at that time felt that that particular facility did not provide a substantial enough economic impact by granting the full license just because of the number of seats that are available inside the restaurant.
Have they expanded the spaces at all, or is it the same size?
To my knowledge, I don't believe that they have, but obviously the applicant is in the audience that could answer that question more directly.
Okay.
Move to open the floor.
Okay.
second.
Move first and second to open the floor, all in favor?
Aye.
Aye.
Opposed, motion carried. Would you people come on up and state your name and address for the records, please?
You could,
Nope, sit down right by the microphone, pull it up to you so we can all hear you.
My name is Enrique Quintana. My address, my home address, 2617 Oakwood Drive, Green Bay, Wisconsin.
Okay. You want to explain your operation?
I want to be a family restaurant to do breakfast, lunch, and dinner. So I open to 6 to 8 o'clock. And so I start selling beers and wine for now only. In case you got a extended license for liquor license. is what I got now.
Okay, so you're just doing, did I hear you say lunch and dinner?
Breakfast, lunch, and dinner.
Breakfast, lunch, and dinner. Okay,
Yeah.
okay. Okay, any other questions for him?
Have you expanded the building at all?
No, it's the same size.
The same size.
Same number of seats?
Yeah.
All the cooking will be done inside?
Yes,
Okay,
not outside like Tom.
okay. Okay. So you understand you are temporarily operating with a beer and wine license?
Yes.
Till it comes to the village board,
Yep.
okay?
I guess I'm going to move to deny it, because I think if the board previously, I wasn't on the board that granted the prior business their license, but if they thought that it was too small to warrant a full Class B beer, Class B liquor, then I don't know that that's going to have changed at all.
I
So I,
understand where you're going,
the
yeah.
prior business had a Class B beer, Class C wine, and I guess I would think that this should continue for this business then.
Okay,
So I guess I would move to deny this motion.
this motion, okay, and it still will go to the village board for
Yeah, the board
that
has to
approval.
rule on it.
Okay,
second.
okay, we got a first and a second, all in favor?
Aye.
Opposed?
Aye.
Just as a point of clarification, obviously, this committee is recommending to the village board. So the motion is to deny the application as it's being presented. If there's a recommendation, however, that the board could use that would either grant the license if that's what you desire, right? So if the desire is to ultimately grant a Class B beer and a Class C wine license,
Yes.
my thought would be I would make another motion that would create that recommendation, that the applicant should be considered for a Class B beer and a Class C wine only license,
Okay,
even
I'll-
though the actual application that was received for the combination would be denied.
Sure, that makes sense.
And you can make that recommendation.
I'll move that they be granted a Class B beer, Class C wine.
Wine, okay.
I'll second.
And you'll second that, okay. Okay, all in favor?
Aye.
Aye.
Opposed? Motion carried. Okay. See you the 22nd at the board meeting.
Thank you.
Thanks.
Move to close the floor.
Oh, yes, move to close the floor. Go ahead.
Second.
All in favor?
Aye.
Aye.
Way to go, Joanne. Okay, Joe, one more, consider and discuss act on draft operation license approval policy.
Yes, thank you, Gary. This particular item is being brought before you primarily because of internal discussions we've had as staff as it relates to the issuance, or I should say, more the appeal of denials for operator licenses. We have, at any given point from month to month, a number of individuals that will appeal a denial for an operator license. And oftentimes, this committee and the village board deliberate and review the applicant's materials and make a determination of whether a license should be granted. Oftentimes, there are conversations and questions that come from both committee and board about the background on the individual that's applied or appealing the decision, but also the context and how we got to the basis of denial to begin with. And I know in my time here, in less than 3 years, we've reviewed criteria of denial several times that Chief Ewell has put together. And so what I wanted to do is kind of take that language that we have for the basis for denial and add some additional context to it in drafting a formal policy that not only staff can use, but also both committee and board can use in determining whether or not an applicant's appeal for denial should be granted. So I'll walk through the approved policy with you just at a high level and then answer any questions that you may have. By and large, most of the context that's in here is information that we presently do. So this isn't necessarily a change in practice, but more or less putting things in writing so not only we as staff, but also you as committee members and board members, as well as applicants, have an understanding for the basis for both approval, denial, and process. So real quickly, within the policy, I'm going to touch just briefly on Section 3, because that kind of delves into more of procedural matters. Right now, what happens is an individual comes to the clerk's office, applies for an operator's license. The clerk does an initial review, and although it says initial review, it is a pretty comprehensive review of the application materials to ensure that the applicant has met the requirements of the application, not necessarily of whether they should be granted a license, but have met the requirements of the application, meaning all of the sections of the application have been completed satisfactorily, and if any information is missing, there's an effort made at that point to ensure that the information is provided. Oftentimes, if we have missing information on an operator's application, it is related to the section that delves into arrests, convictions, and offenses of the law. Oftentimes, for whatever reason, individuals forget their record, whether intentionally or unintentionally, and so there's an effort made to ensure that they have listed, in fact, any and all offenses that are related to the application material. So that initial review is pretty comprehensive with that applicant. Once the application is received and it's deemed satisfactory from a completion standpoint, that information is then forwarded to the Public Safety Department, where Chief Ewell, either he or one of his designees, conducts a comprehensive background check on that individual. It could include a criminal, traffic check, other license issues, things of that nature. If necessary, that record check may involve an interview or a conversation with the applicant, just verify and validate information that may be found on the record. Applicants are required to provide all of the requested information on the application in order to consider that application complete. One of the things that we want to make sure that we're clear on is that applications with missing or incomplete information regarding arrests and convictions would be denied. So that's an incomplete application, and whether they intended to leave it blank or were attempting to mislead us, we would ultimately deny that application. If you think about it from an employment standpoint, if an individual applied for a position of employment with the village and either left information, important material information off of the application, or had an intention to mislead the employer, that employee or candidate for employment would not be considered for a job. A license is similar in that regard. And so incomplete information would elicit an automatic denial of that applicant, even if they did not intend to mislead or misinform. We'll touch on the concept of corrected applications later on, but there is an opportunity through the denial appeal process to request an opportunity to correct an application to ensure the record has been identified. But we'll touch on that briefly. So the chief gets the record. If the record has passed, meaning the arrest conviction record has been satisfied, the chief would provide a recommendation to the clerk that the record is clear and that the applicant is eligible for a license. If the individual has an arrest or conviction record under the criteria that we've established, both in this policy and under our previous provisions, then the chief would recommend denial of that application. The clerk then provides to the applicant a notice of denial, and within that notice, the village clerk office states the reasons for the denial and provides a copy of the municipal code so that they have an actual copy of the procedures used for appealing that determination. If you recall, a few months ago, maybe even a little bit longer than that, the village adopted a revised ordinance as it related to operator licenses that permits the village clerk from the opportunity to issue operator licenses without committee or board approval. And that change was the result of changes that happened at the state level, statutory law change that would allow the clerk to issue licenses so long as an individual does not have substantially related criminal activity on their record. And so the clerk can issue a license. If the individual is denied at that point, they are also given instructions on how they may appeal that denial. One of the requests that we have is that in order for an individual to appeal their denial at the staff level, they would need to do so in writing. versus automatically just placing them on the agenda. Oftentimes that is what we see now is where we deny them, we place them on the agenda automatically, and oftentimes the individual doesn't show up. So what we want to do is if they genuinely wanted to appeal their denial, then they would do so in writing. Doesn't have to be anything overly formal, a simple email indicating I wish to appeal my denial to this rejection. At that point, upon written notice, the village clerk sends the application materials to this committee. The committee ultimately has an initial hearing, provides a recommendation back to the village board to either uphold the denial or the appeal. The committee will interview the applicant and make recommendations to either grant or deny, as I mentioned, and the village board ultimately makes the final determination based on the recommendation from committee. At that point, if the committee recommends denial of the appeal and the village board upholds that denial, the applicant's next course of action, if they so choose, would be to apply to the circuit court pursuant to Wisconsin state statutes. So they could appeal, the village board being the final determining body of the village. The next recourse for that individual to appeal that denial would be the circuit court. So that's kind of the process. And again, that by and large, that's generally what is happening today without so much in writing. Section 4 deals with the criteria for denial. And again, much of this is being completed today, but we are adding much, much more context to why and how we are issuing those reasons for denial. The first thing I'll mention is that the chief is looking at a comprehensive review of the individual's criminal arrest and conviction history. However, based on the licensing activity, only certain arrests and convictions can be used in determining denial. So we have to make sure that whatever that arrest or conviction is substantially relates in some form or fashion to the licensing activity. If it doesn't, it may not be considered for basis for denial. And so when we present or an appeal is presented to committee and board, oftentimes only the matters that are pertaining to the licensing activity are presented to the committee. Okay, so we want to make sure that we're clear about that so that it is not considered discriminatory practices, that we're not discriminating against somebody because of the number of arrests or convictions should they not relate to the licensing activity. So guideline number 1 delves into felony matters. So first and foremost, if the offense substantially relates to the circumstances of the job or the licensing activity, and it results in a conviction of a felony, that is an automatic denial. And state statutes do not allow allow a municipality from issuing a license to an individual that has a felony so long as it substantially relates to the licensing activity. Now, if that individual is duly pardoned, then obviously there may be some circumstances in which that license could be granted, but that would be determined on a hearing as it relates to the denial itself, right? That would be evidence that would be presented by the individual in the event that they appealed the denial. Guideline 2 is if a licensee is convicted of an offense substantially related to the license activity. So this is a non-felony, could be a misdemeanor, could be a simple municipal citation, something non-felony related, but again relates to the licensing activity. In this particular case, any person who has been convicted or has a current charge pending for 1 or more offenses within the last 5 years, or 2 or more offenses arising out of separate incidents, so not a single incident with 2 citations, within the last 10 years in the following categories below. So violent crimes against the person of another, including but not limited to battery, disorderly conduct, sexual assault, injury by neglect, negligent use of a motor vehicle, or intimidation of a victim or witness. B would be crimes involving cooperation or really the lack thereof with law enforcement officials, including but not limited to resisting or obstructing a public safety officer, bribery of public officers, employees, eluding public safety, bail jumping, hit and run, perjury, or acts or threats of terrorism. And then finally, C, manufacturing, distributing, delivering a controlled substance or controlled substance analog, in maintaining drug trafficking place, possessing with intent to manufacture, distribute or deliver a controlled substance or controlled substance analog. So A and B are really crimes against people, and so those are what we view as substantially related, because issuing an operator license to somebody that's going to be serving people alcohol are dealing with people, and these are crimes against people. Paragraph B is related to public safety. So if we're conducting an investigation, we want to ensure that that applicant is going to be cooperative with law enforcement. If they have a history of not being cooperative with law enforcement, that could be a problem for us as well. So we view that as substantially related. And then item C, obviously dealing with illicit drugs, that is just, I guess, common sense. Under guideline number 3, these are items that are very specific to alcohol. So these are circumstances that substantially relate to the job, and these are individuals who have been convicted or have a current charge pending for one or more offenses arising out of separate incidents within the last 2 years. So if an applicant comes before us and has any of these things, at least one in the last 2 years, they would be issued a denial. So they have some type of alcohol beverage offense. So under Chapter 125 of Wisconsin State Statutes, or a municipal code violation under Chapter 3. If they've had any citations related to those, maybe they were a previous operator in another community, and they've been issued a citation or have a pending charge, that would be considered a basis for denial. If they've operated a motor vehicle with a prohibited alcohol concentration amount in excess of 0.08%, again, DUI type situation. If they've had open intoxicants in public places or in a motor vehicle, possession of a controlled substance analog without valid prescription, or possession of drug paraphernalia, operating a motor vehicle while under the influence of intoxicants or drugs, so not necessarily alcohol, but drugs in general. And then disorderly conduct, criminal damage to property, solicitation of prostitution, or other prostitution-related offenses wherein the offense involves an incidence in a place that either is or should be a licensed premise. So an alcohol-related premise. And these are all very specific alcohol-related offenses. If an applicant has one or more offenses over the last 2 years, automatic denial. Under guideline number 4, it is basically delves into the concept of a habitual law offender. So if you are considered a habitual law offender, that also could disqualify you from obtaining an operator's license. We've identified through definition what a habitual law offender is based on recommendation and legal guidance from the League of Wisconsin Municipalities. Ultimately, under those guidelines, it basically extends to 2 or more offenses, each a separate incident, within the immediately preceding 1 year. So if an applicant comes in today and then over the last year has had 2 law offenses, again, substantially related to the circumstances of employment, they would be considered a habitual law offender and they would be denied the license. If they've had 3 or more offenses, each a separate incident, within the immediately preceding 5-year period, that again would fall under that habitual law offender. And then if you have 4 or more offenses, each a separate incident within the last 10 years. So if you've had 2 offenses and they date back to 1995, it would not necessarily be a basis for denial, because it's extended long enough out where they would no longer be considered a habitual law offender. Now, if those offenses, one or both, were a felony, then that would fall under guideline 1 and it would be an automatic basis for denial, so long as that felony is substantially related to the licensing activity. Okay, so guideline number 5 is based on that concept that we talked about earlier about the individual completing and truthfully filling out the application. So as I mentioned before, if an application is found to be incomplete, whether intentionally or unintentionally, it would be a basis for denial. The individual could appeal that denial and then approach committee and board. If an applicant who knowingly provides false information on the application, that application should be denied. The applicant and even if they were to appeal, the applicant shall not be eligible to reapply for an operator license for a period of 1 year from the date of the denial of the application. So they have to wait a year before they could reapply, and hopefully at that point they can include the appropriate information. If the committee determines that the information was intentionally omitted from the application, the applicant shall be denied, and the applicant shall not be eligible again to reapply for that 1 year period. If the committee determines the information was omitted from the application due to inadvertence, a mistake, or excusable neglect, the committee may allow the applicant to submit a corrected application and recommend granting of the license if the applicant is otherwise qualified. So you may have an individual come, appeal their denial based on a lack of information on their application. They provide you substantial evidence about why this was inadvertent, how it was a mistake, and it was an excusable type neglect on their part. And if the committee feels strongly enough that this individual is being truthful and honest in their representation of facts, they could allow that applicant to resubmit an application. If the committee or board allows the individual to do that under those terms and that sequence, the individual would have to reapply, pay the fee again, because we've already gone through and processed the original application. Again, just so everyone is aware, because the license is a privilege, the issuance of which is right granted solely by the village board. The village board reserves the right to consider the severity and facts and circumstances of the offense when making its final determination to grant, deny, or not renew the license. The next section, which is section 5, delves into both the committee's review and ultimately leading to the village board's final determination, again, on the appeal. Wisconsin state statutes do provide some context to what would be considered permissive as far as evidence is termed for the individual's appeal. So within Wisconsin state statutes, chapter 111, competent evidence of rehabilitation and fitness to perform the licensing activity may be provided as evidence that would allow you to grant the license. So, and statutes identify 2 very specific things that they can present to you in evidence to show that they have in fact been rehabilitated from whatever conviction or pending charge that they are facing. There's specific items related to Department of Defense, as well as any copies of local, state, or federal release documents as it relates to the crime in which they have committed. In addition to that, the applicant should provide some type of documentary evidence to both the committee and board that would be sufficient for the committee or board to uphold or uphold the appeal of the denial. So the individual should be able to provide evidence of the nature and seriousness of any offense of which he or she is convicted, the evidence of all circumstances related to the offense, including any mitigating circumstances or social conditions surrounding the commission of the offense, the age of the individual at the time of the offense was committed, the length of time that has elapsed from that offense, any letters of reference by persons who have been in contact with the individual since the applicant's release from any local, state, or federal correctional institution, and then any and all other relevant evidence of rehabilitation and present fitness provided. So with that, what you're looking for is an applicant that's coming to you with actual physical evidence, not just I've been rehabilitated or I've seen the error in my ways and I've made corrections. What the committee should really be asking then at that point is how? How can you show or demonstrate that you have met the requirements of rehabilitation as outlined within our policy, not just based on the appeal, the emotion, or the look or feel of the applicant that's being presented. That can lead to discriminatory practices, and that's ultimately what you want to avoid. You want to really look at the basis of facts, and those facts are laid out based on evidence. When an individual is denied and they do issue a letter of appeal or an appeal in writing, I should say, They will be given this information as well, that these are the things that you need to present to both committee and board to prove and justify why you should be granted a license. So they will also have that information presented to them so that they can be prepared in their effort to appeal their denial. So at the end of the day, the committee, when it does approve the license, so it upholds the the appeal, or ultimately denies the appeal, the committee and the board should state specifically the reasons for that approval or denial. Ultimately, that leads to a more correct motion, one that is less subject to appeal to the circuit court in the event that the individual would like to do so. So possible outcomes are recommended approval of the license based on the applicant providing credible evidence of rehabilitation. So maybe that's the basis for your approval. Or recommended the applicant be tabled for a period of 31 days so the committee can re-review the application materials at that time. Maybe the individual has presented a substantial amount of evidence at the appeal hearing and you don't have sufficient time to review it before a decision can be made. Or the application is recommended to be denied based on the violation of a guideline. So again, having this written policy, you could state under guideline number 5, this individual did not provide material information related to their arrest or conviction record, and thereby we are denying the operator's license. And then if the applicant fails to appear, obviously even if they issue in writing a request to appeal their denial, but they fail to appear, the basis for your denial can be they failed to appear during their appeal hearing with the committee, thereby we recommend denial. So with that, I will answer any questions that you may have regarding the proposed policy. This would ultimately be more of an administrative policy that's administered internally with staff, but obviously it does have input or impact on the committee and the board's processes as well. So with that, I'll answer any questions.
Joel, am I understanding this correctly, that the staff will investigate this a lot deeper than what we have in the past, and the questions that the person, if he comes for a review of being accepted, we wouldn't have all the unanswered questions that come up at this table?
I guess I would say probably no. I mean, Chief is going to conduct his background check as it is today. I think what this does is it hopefully provides a little context to the committee and the board as well that, okay, how did you make your determination for denial? It's one of these criterias or guidelines that have not been satisfied.
Okay.
Right? So under section section 4, the criteria for denial, let's say it's guideline number 3. So when you would receive an an appeal for an operator license denial, you'll get your cover page included in your agenda packet that will indicate that this individual has requested an appeal to their denial. Their application was denied based on it not meeting guideline, let's say number 3. Okay, so it will identify to you at both board and committee that the applicant failed to meet the requirements under guideline 3. And that could be an individual had an OWI or DUI offense in the last 2 years whereby they had a PAC in excess of 0.08.
Okay.
Make sense?
Okay. Any other questions?
I have one. On the next page, on page 66, it says subject to Wisconsin's fair employment law. And then further down, it says pending arrest or conviction record unless the record substantially relates to the licensing activity. Who would determine that?
So the licensing activity is primarily going to be identified under guidelines 2, 3, and could theoretically be 4 as we're dealing with habitual law offense. But let's say an individual has a crime against another person. We could view that as substantially related. because serving of alcohol to others is dealing with people. Okay. Obviously, we have situations where we're dealing with alcohol or controlled substances. Those substantially relate to the licensing activity. The question often comes up, so let's say somebody has been charged with theft. Maybe not a felony offense, but it's theft. Could that be deemed substantially related? Well, one person would say yes, because they're going to be tending bar and they might steal money from the till. But the licensing activity doesn't regulate cash. It regulates the distribution of alcohol. So that is more of a concern to the employer, as more so than it is to us as us licensing the activity of the distribution of alcohol, if that makes sense.
Thank you.
Okay, anything else? Joe, if the recommendation to you would be to, let me see here.
I can make a motion to recommend to the village board to
Okay.
adopt the operator license
There
approval
you go.
as presented or amended.
Second.
All right, got a first and a second, all in favor?
Aye.
Opposed? Motion carried. Okay, understanding that somewhat. Item F, consider, discuss, act on Village of Ashwaubenon ordinance number 08-2-23, amending the prohibition of loud and unnecessary noise. Patrick, I believe you got that one.
Thank you. The Department of Public Works requested that the committee and the board review an ordinance creating an exemption to our noise ordinance. As it stands right now, the noise ordinance kind of basically broadly states no noise shall be permitted in the village that makes such that would annoy loud noises, let's just put it that way. There's a lot of criteria that kind of go into it. Loud noises, with minimal exemptions. There are some exemptions where if something is deemed an emergency, it doesn't abide by a timeline. The ordinance also says that no noise shall be permitted between 10 p.m. and 7 a.m. By a certain distance. Following a lot of other municipalities that have exemptions for utility projects or village construction sites, basically DPW staff, their vehicles, this exemption would allow municipal utility projects, DPW vehicles, their equipment, their contractors, and other kind of like operations, other works to be done outside of the noise ordinance. So this would specifically exempt village staff and crew for necessary projects during reasonable hours. So they wouldn't necessarily have to abide by that 10 p.m. to 7 a.m. rule if there is a project or construction site, village construction site, or maybe like a municipal utility project that needs to be worked on by a certain time. So perhaps there's a time that this project needs to be done at 6 a.m. to 6:30 a.m. based on that particular needs of the project. This would exempt just that village staff and crew, again, during reasonable hours. It wouldn't necessarily say that DPW crew could go out and start working on anything at 1 o'clock in the morning, because I would consider, I think the committee and the board would consider that to be unreasonable hours in the event of an emergency. So an emergency, say a tree falls in the street, needs to be taken out right away, or a utility line is down, or a water main break, 3 o'clock in the morning, DPW crew or water utility crew would be out there fixing that issue right away, and I think that would be deemed as an emergency. So the emergency operations, that has an exemption in the noise ordinance, basically whenever it's deemed an emergency by village staff. However, for other maintenance projects, utility projects, construction sites, or like village work crews, that would have to be done during reasonable hours. For more specifics on that, I think Brian might have a pretty good example of when that would take place.
Yeah, sure. So what kind of triggered this is when we were doing work out on Morris Ave, so the reconstruct project out on Morris Ave, when they were relaying the sanitary sewer pipe, they actually had to bypass pump the sewage. During that time, of course, sewage flow is 24/7. So they did have to have pumps set up that were running off from what's commonly referred to as whisper watt generators that generate white noise that run 24/7 to allow for the construction operation to occur. Another good example of that, Missy Meadow also had some pond dredging that occurred before my time here, but in order to dewater that pond, the pumps had to be ran 24/7 in order to allow for the dewatering. So that's kind of the standard operational items, I would say. Outside of that, of course, the emergency items, we'll use an example. We had some power poles that were knocked down last weekend out on Broadway. So we're out there in the middle of the night with our trucks that have backup beepers, stuff like that, getting a road closure set up. So pretty straightforward that way. Another operational thing is snow removal. That happens all hours of the night. Unfortunately, our trucks, they have mufflers, but they make noise. They definitely do. So it kind of just cleans things up and allows us to operate as needed. So with that, I can definitely answer any questions if there are any questions.
Yeah, just following up on that, it really only applies to the village staff and crew. This doesn't relate to any private developer, contractors working at all hours of the night or outside their reasonable permitted work hours. It's really just for village staff.
Or contracted crews. So say we use a utility contractor because we have a water main break. They're contracted through us. So this doesn't mean that you're going to have, a TDS project or something like that going on all hours of the night. It's strictly village utility projects. So.
What about like road construction? Because I could see where, like, for example, 172, where the traffic flow is so much lower at night, they're trying to do a lot of the work at night. I mean, that makes sense to me. It's going to be loud, but they're doing it at night so that they can get it done when there's no traffic.
Right. If we were to ever have a project like that, I would definitely have, I'd bring it in front of the board. It kind of really depends on location. You can definitely do things like that. Say you're, in the commercial industrial area, not a big deal. If we're going to do something like that, I would say in a residential area, that's something that we would definitely come before the board to get the board's direction to make sure that we are all on the same team saying, yes, this does have merit. It does make sense to do this work at night. So.
I think I know where you're going with that question. All right, any other ideas, questions, or thoughts? If not, let's obtain a motion for the board here.
I'll make a motion to recommend approval of ordinance number 08-2-23, amending the prohibition of loud and unnecessary noise.
I'll second it.
First and a second, all in favor?
Aye.
Aye.
Opposed, motion carried. That ends the action items. Any items of interest for the next agenda, contact staff. If no other questions, I'll obtain a motion to close this meeting.
So moved.
What a woman.
Second.
First and second, all in favor?
Aye.
Aye.
Opposed, motion carried. Thank you very much. Have a good evening.